My name is Stephen Wilkinson, and I lead the Diakonia International Humanitarian Law Centre. Just very briefly, the Diakonia International Humanitarian Law Centre is a global legal centre of excellence. It's really designed to share knowledge about and promote the laws of war. The humanitarian community, in particular, is one of our kind of central constituents. We're driven by the belief that the law is a tool to increase protection in armed conflict and improve lives. We are independent and we develop our interventions based on the greatest needs for protection. We also undertake our work on the basis of feminist principles. We at least try to use innovative and inclusive ways to share knowledge about and promote new ideas when it comes to respect of IHL, ultimately for the goal of ensuring greater protection. And therefore, as I think Ezekiel very well stated, a project such as the Generating Respect project is of key interest to us because, again, I think it will play such an important role in helping to strengthen and help be maybe more innovative in some of our strategies when it comes to the promotion and respect of international humanitarian law. In addition, it's maybe also important to mention that the IHL Centre is hosted by a faith-based organisation. And so through our development work in particular, we also have extensive experience of some of the kind of important aspects of being a faith-based actor, but also some of the challenges that can come with that as well. I'm very honoured to kind of chair this first panel. I'm joined by two excellent panellists. Maybe just before I hand over to Dr. Eve Massingham, I think it's important to maybe take a few moments to reflect upon some key broad issues when it comes to this very important topic of religion, its actors, and international humanitarian law. I think the interplay and interface between religion and international humanitarian law is not just interesting, it's compelling, it's important, and still rather underexplored. And of course, this is why the Generating Respect project, I think, is really an important addition to this field. The connection between IHL and religion could be neatly summarized as being about kind of common reflections of fundamental values. And it could be seen that all major religions in some form or other promote very similar values to international humanitarian law. So therefore, on one hand, religion can really be seen as a rich kind of fund or source of doctrine and principles, many of which are actually recognized as binding under international law. It could also be said that the law as such is rather powerless unless it's backed by forces beyond the legal system, such as customs, public opinion, but also religion. On the other side of a coin or another dimension, religion is and is not benign. And often we see that religion or religious doctrines have been used or presented as justification for violating human rights and international humanitarian law. Of course, very compelling arguments that this is rather a pretext used to justify or hide behind the real reasons for the struggle for power. I think however you see this, whatever your take, religion as a kind of a power of good, bad, or indifference, we cannot in broad terms dispute its significant level of force and influence across many forms of human interaction. And of course, that includes situations of armed conflict. So following those rather broad and non-specific comments, I'm delighted to be joined by two superb panelists. The first, Dr. Eve Massingham. Just very briefly, Dr. Eve Massingham is a senior research fellow with the School of Law, University of Queensland. Eve's current research focus is on diverse ways in which the law constrains or enables autonomous functions of military platform systems and weapons. I think very pertinently for her intervention, she's a co-editor of Ensuring Respect for International Humanitarian Law, and she's published a number of book chapters and journal articles in the field of IHL and use of force. So in her intervention, and I've had the pleasure of reading her paper, she'll be addressing the possible role of religious actors in generating respect for the laws of war in relation to everyone's favourite, or perhaps least favourite provision of IHL, and that's Common Article 1. The floor is yours, Eve.
Thank you very much, Stephen, for the introduction. I'm saying good evening, but good morning and afternoon to everybody, and nice to see a few familiar names on the list of participants. I'm joining you from the lands of the Turrbal and Yagara people. You may be more familiar with this as the geographic area known as Brisbane, Australia. And it's a great privilege to live and work on the lands of the oldest of continuing cultures, and I pay my respects to their elders past and present. I'd like to thank the conference organisers and the project team for this opportunity and also for accommodating my time zone. And just before getting into the content, also to acknowledge my research assistant, Kirsten McCruvey, who's listening in, and thank her for her work. I do have a PowerPoint. I've just tried to share screen, but it says I don't have hosting privileges. So I'll just continue, but if there is the opportunity to bring a PowerPoint up that I had sent through to the organisers, that would be great. The starting point, try now. Lovely, thank you very much. So hopefully this is just coming through for everyone. The starting point for my research and my interest in this particular topic and conference is this quote. Here you'll see that it's a 111-year-old quote, but is one that I still think has a lot of relevance. And it talks about sort of the role of statesmen and lawyers in international law, but also all classes of the community in every nation, including journalists, merchants, artisans, and of course, clergy who more broadly we would think of today as religious actors, and of course are the focus of this conference, and the need for a fuller knowledge of the rules of law so that the value of international law can be better appreciated, and the role of all these different actors in respecting the laws of armed conflict. And so with that starting point, and also with the previous work that I've been doing, and thank you, Stephen, for mentioning the edited collection around ensuring respect for international humanitarian law, which I've just included here so you can see the various different themes, I guess sort of the thematic areas of international humanitarian law from which those involved in that particular project built on some ideas that were actually a part of my PhD thesis to think about the different actors and the different aspects and thematic areas of international humanitarian law that are relevant to ensuring respect for international humanitarian law. Now, this project had a word limit, as these things do, but there are many other chapters that could have been included in this. And I think a chapter on religious actors is definitely one of them. So that's where the further work that I'm doing now and the paper that I'm doing now goes to. Now, obviously, many of you are very well familiar with this particular provision of the Geneva Conventions, the Common Article 1 provision to respect and ensure respect for the Convention and their protocols. And many of you will, of course, be familiar with the International Committee of the Red Cross's more recent Commentaries Update project, which has brought a little bit of renewed interest to a provision that definitely attracted very little attention in the drafting phase for what was to be Common Article 1 to an international legal framework agreed to by all nations, and is a provision that has had a variety of different interpretations, from this idea of an innocuous sort of opening phrase that didn't really do much to a nucleus for a system of collective responsibility. Now, for those of you who've followed the ICRC commentaries, you'll be aware of the discussions around the respect idea and this idea of ensuring respect, and the fact that there is some controversy in the state responses and indeed academic responses to the third state component of ensure respect, to the idea that a third state might have an obligation in relation to states that they can have some capacity and influence over. The work that I've done in relation to ensure respect is essentially saying that, look, it doesn't really matter whether you agree that this is a specific legal obligation or not. There are clearly some practical measures that are taking place in a variety of thematic areas. And so looking at what those practical measures are is the important part. So bearing in mind that there may be an obligation for third states who have the capacity and influence to play a role, and that clearly this is an obligation of states, but it is also an obligation of those who need to be involved to allow the state to ensure respect. And I've sort of talked about it here as a state plus obligation, and state plus all of these other actors who are relevant to the execution of, at the very least, a state's obligations to respect IHL themselves, which is not a particularly controversial aspect, whether or not you accept the third state additional aspect as well. And clearly religious actors are a part of that. So taking the opportunity to sort of engage with this and engage with this work meant looking at, well, what are the different roles of religious actors in relation to ensuring respect or giving effect to the respect obligation? And so I think it's clear that obviously there are those who are the specific military religious personnel who are mentioned in the conventions, who have a specific role as serving, and by this I mean military service religious personnel. But then the other religious actors, I think, really fall into sort of three categories. There is the religious actors serving communities that are actually experiencing conflict themselves, and their roles and their obligations. There is the religious actors who are serving diaspora of communities in conflict, and I think they have a specific role, particularly around some of the ideas about language and communication, which I'll speak to in a minute. And then, of course, there's the role of the religious community who are serving the religious personnel who are serving the broader community, and the role that they can play in respecting and ensuring respect, and their interaction, of course, with the state itself. So thinking about these four different groups, in the paper, what I'm seeking to explore is how they can have a role in respecting and ensuring respect. And I think there's a few different ways of looking at the capacity and the influence that they can have. An important aspect is, of course, the relationship between the religious actors and the state. And this, of course, looks very different in different jurisdictions around the world. There are some jurisdictions where this is a very close relationship. There are some jurisdictions where this is very deliberately not a close relationship, and constitutionally are very separate issues. But the way that even in those contexts, states treat religious actors is quite unique in terms of different to how they might treat corporations or other commercial actors. And so exploring that in a little bit more detail is one of the aspects of my paper. I'm conscious I only have another minute or so in the allocated time, so I'll just mention a couple of the other areas that I want to explore more in the paper and hope to engage more in the discussions about them. So the second one is the language and communication, and the way in which religious actors speak about and communicate international humanitarian law issues, the way in which they influence members of their congregations in terms of understanding and education, and of course, we know from historical examples and current examples, the role and the influence that religious actors have to play. And of course, the Generating Respect project research in this area is very significant. The third area then is engagement, and I'm talking particularly here, I guess, about the role that religious actors themselves play sort of in the humanitarian response, and that is a key role that religious actors can play in times of armed conflict, and of course in the education of diaspora and the broader community. And then the interpretations of religious texts and beliefs. Again, I think this is linked to engagement and language and communication, but a specific area where there is capacity and influence of a religious actor. And I think that this ties in with the broader obligations of states. These are the themes, these three themes are the themes emerging from the work that I've been doing to date on ensuring respect. And I think there's a clear role for religious actors in terms of engagement and communication and language in these emerging themes. And perhaps in some ways, the role of religious actors is not so different to the obligations of states to encourage respect for IHL, to build respect through legal and normative frameworks. Perhaps there's less of a role in terms of direct action to enforce respect, but perhaps in terms of humanitarian response and humanitarian action, there is a role to play. My broad conclusions around ensuring respect is that it's essentially a toolbox of measures. There's not a checklist, but there's a range of different measures that states can take, and there's a centrality of due diligence in that. And I think there is, well, I hope that this is a catalyst for discussion about how religious actors can be involved in supporting states and giving effect to the Common Article 1 obligation. So I'll leave it there, Stephen, and look forward to some further discussion.
Fantastic. Thanks, Eve. I think having worked in particularly Israel-Palestine context for a number of years, this is often a big hot topic, Common Article 1. What does it mean? A lot of pressure from diplomatic actors to actually have that clear, well-elaborated set out, what do we need to do? Whereas, again, as you say, I think it's really looking at a toolbox. I really like the approach of this due diligence concept, really kind of about encouraging others as well. So sometimes in the state dialogue we've had, often what they say, well, we're doing this, we'll do our démarche or whatever it may be. And so we'll leave us alone. But actually, I think maybe changing the dialogue slightly, making it more about, okay, but you can encourage others to also play a key role in that, I think is a really an important approach. I just had, if I may, just a question, and first one relates specifically to this topic, and one is maybe a broader IHL and religion question. The first is, to what extent, because I often find that in a lot of scholarship at the moment, or we tend to box different actors. You know, we have a lot of papers on non-state actors. Then we have hopefully now some great papers on religious actors. But I was, you know, as important as religious actors are, I actually was struck by, well, actually a town planner could also be a very important actor. So I'm just wondering, to what extent could some of the principles and concepts that you raise in your paper, actually could they be extended much broadly to an array of different actors? I'd be interested to hear your comments on that. And then I'll maybe follow up with another question if we have time.
Thanks, Stephen. And yeah, look, thanks for raising the checklist issue. My co-editor of the publication, Annabelle McConaughey, who was very influential and supportive of my PhD process, and I convinced her that she wanted to edit the publication with me. You know, her and I had many discussions, and we were very convinced at one stage that we were starting this project to create this checklist and we came undone. It became very clear that there wasn't a checklist. It was a pipe dream, and what we really needed to do was, you know, get different people to reflect on different practical measures that may be able to be taken, but that it was always going to be a range of options, and this idea of a toolbox of options rather than clear options. I think it's a really good point you raise, and when I first started thinking about this conference and this topic, you know, one of the questions that actually Iona put to me was, you know, is this a separate category? When you're talking about ensuring respect by private actors, is this a separate category? And I think the answer is there are some aspects that are unique to religious actors, and that is because they have this specific role within the Geneva Conventions. I mean, like medical personnel, they're given this particular role. However, there are lots of obligations where I think there's a lot of synergies across what private actors can and should be doing to support states in their obligation. It's interesting that you mentioned town planning. I've been sort of working in the field of IHL education for most of my career, and I had a town planner turn up to one of my one-day workshops on introduction to IHL, and it was the most exciting thing for me, because I was like, oh my gosh, you're actually a really important demographic that don't normally think about these sorts of things. And actually having town planners thinking about IHL is a really important point. We get the journalists, we get the lawyers, we get religious actors, but engaging all aspects of the community. And that's why I really like the Higgins quote from 111 years ago about international law generally. This is not something that a single actor can do alone. So I think the short answer to your question, now that I've rambled for a bit, is there are some aspects that absolutely are unique to religious actors. And I think that is very much linked to the very clear influence that they have in particular communities. But there are some actions that are very clearly the role of all private actors.
Oh, brilliant. No, thank you for that. We do have a bit of time. So you kind of mentioned it, that the IHL actually does set out in several provisions of the convention some kind of specific role. I was just wondering again, and I always like to be a bit critical, or do you feel that kind of having that special role is well justified still, or is it a bit of a remnant or a relic of the time period in which the conventions were put together? So any reflection on that, I'd be very interested to hear.
I guess my answer to this comes from my own experience of training. So I haven't served operationally, but I have served as a member of the Australian Defence Force in the Army Reserve. And whilst it might seem a little bit antiquated, the role of a religious actor or a guidance type actor remains quite significant in the military training context. So my own personal experience was that that role still exists to provide that sort of personal and welfare support. And my experience with that is those individuals in that role visiting soldiers on training operations. As I said, I haven't served overseas, and providing that support. So whilst clearly the language is antiquated, and the Geneva Convention's commentary has recognised that and said, look, this is clearly religious actors of all denominations, and perhaps an even more modern interpretation is that there's a more wellness and spiritual aspect to it. I do still see that as quite a significant role within the armed forces. And so I think that there remains some justification for having that as a particularly identified group in addition to medical practitioners. But it's a really good question that I haven't given a lot of thought to.
Many thanks. And I'm aware that I have lots of other questions I could ask you, but we should perhaps move on to our other panelists, and also very important to have lots of time for some open questions as well. So the next panelist is Dr. Maria Varaki. Dr. Maria Varaki is a lecturer in international law at War Studies, King's College London. Before moving to London, she was a senior research fellow with the Eric Castren Institute of International Law and Human Rights in Helsinki. She holds a PhD in international criminal law from the Irish Centre for Human Rights, assistant professor in international law at Kadir Has University, Istanbul, and many other interesting, I think, for her interventions. She was also a postdoctoral fellow at the law faculty at the Hebrew University in Jerusalem. I'll not say any more than that. I think her title of her presentation is kind of one of those kind of mysterious but hopefully very interesting titles. So I introduce Maria and her paper, Generating Moderation from Istanbul to Jerusalem and Athens. Maria, you have the floor.
Hello, everyone. Can you hear me? Okay. Good morning, everyone. I'm speaking from Terminal 2 at Heathrow Airport. I will be boarding in 45 minutes, so I apologize for all the noise and the disruption, but I really wanted to be with you. I also want to apologize to Stephen, to Ioana, Ezekiel, and Eve for sending my note paper that late, but I'm very happy that I managed to do it. So having said that, my paper is I think it's very, very different, with different and same at the same time. You know, it has similarities with the main theme of your discussion, but also it's very different, you know, from the other papers. And I'm saying that, you know, because my paper is a reflection of actually those concept notes of my experience of the personal experience I had from the research project I worked with young climbers for many years in Helsinki on virtue ethics and ethical leadership. So the first component, you know, I would like to talk about this experience and where I come from, and this is where the moderation comes. The second strand lens of my paper is it very much reflects my anxiety as an academic, how I'm teaching international humanitarian law in an era where there is a massive disillusionment, and how I can convey this criticism without making my students and our students cynical. So it's a personal, I would say, self-challenge. As I say, I oscillate between faith and critique. I challenge myself all the time, but I still want to believe that there is something positive over there. And the third component is a fictional dialogue that, for the purposes for doing justice, you know, for our conference, I didn't develop further, but I give some hints in this note paper. So let's start with the basic. Well, I would say that I belong to these lawyers who very much do not believe that having rules and norms is enough. Yes, it's great. We lawyers, you know, we have I would say, obsession with objective criteria. We need clarity when we come with hard cases. However, I believe that it matters very much the application of law, the way, you know, that individuals can convey messages and can actually, you know, push this pull for compliance, the famous thing, you know, that Tom Frank talked about. So my whole project on virtue ethics was very much about human agency. To what extent different individuals in different contexts, whether they were leaders, academics, religious actors in our occasion, you know, could actually convey a better message that could generate respect, compliance, better understanding. This is a broader project. And in our work, we went back to the Aristotelian theory of virtue ethics, and we identified particular traits that particular people in different contexts should ideally have. So for me, the main trait that I always talk about is phronesis, this practical wisdom, which is combined with moderation, which I consider more and more in my work actually the most important trait when we deal with very complex and nuanced situations where you try to find, you know, what it is possible, oscillating between not being purist, but also being realist, but at the same time being idealist. But also, you know, imagination. We really need people, you know, who can convey messages of positive messages with a tone of imagination. So this is the first component, you know, of where I come from. The second component, as I briefly mentioned 5 minutes ago, it has to do, you know, with us as academics, as lecturers, as teachers of international humanitarian law, generally of international law, I would say, in an era, you know, where we have all nothing matters, we're in crisis. I put that on quotation. We always want to be in crisis. What is the future of international law? You have a conflict, then your students bombard you with questions. Yes, you teach us about this and that, but at the end of the day, nothing happens. Civilians are killed, people are killed. So there, you know, I try to take inspiration via a trend of moderation, as I say. And this moderation comes from the work of very various scholars I study, I read, and I work with. So scholars in the broader sense, you know, like Albert Camus, who I always thought that he was the most interesting intellectual, but also Judith Clark or Albert Hirschman, or in our Aristotle, of course, you know, philosopher, but also Tom Frank. scholars and intellectuals who manifested, reflected this trait of moderation, understanding, the possibility, but also the limits. And the third thing that I tried to do in this note paper was to generate this, to highlight this, the importance of moderation, but also of practical wisdom and imagination via, as I call, a fictional dialogue among three very different personalities. The first one is the ecumenical patriarch in Istanbul, Bartholomew, who is considered to be an open-minded personality, despite being a senior religious leader, someone who started talking to the Catholic Church after many, many, many decades, someone who is considered to be the green patriarch because always he was environmentally sensitive, but someone I know personally, and I'm always fascinated by his moderation, his imagination, his will, to open paths of communication via a sense of humanity. So I asked my students to think about a fictional dialogue between himself, who is still alive. The second personality I asked them to think is Nikos Kazantzakis. Nikos Kazantzakis was the most famous Greek novelist who died in the 50s. He was a deeply spiritual writer. However, he always challenged the official policy of the Greek Orthodox Church. And at the very end, he was almost excommunicated by the Greek Orthodox Church. However, his writings reflect these deep traits of moderation, imagination, and humanity. And the third speaker I invite my students to think of this fictional dialogue is Amos Oz. Amos Oz, the Israeli writer who died a couple of years ago. We cannot identify definitely Amos Oz as a religious leader. Here I would like to say that for me, I understand this and a link with religion broadly perceived among people, who understood religion, but were very critical in the sense, they were evolving into this self-challenge. What is religion? They were against the formalities, but they were going into the substance of religions in the sense, of humanity, of solidarity. And I asked my students, to think, to create this fictional dialogue while they choose a particular event, an event, where they're outraged by violations of international humanitarian law. So in my note paper, briefly I mentioned the case of sieges, where civilians, massively suffer. And so I invite them and I say, how do you think these three people, who come from different eras, from different contexts, how would you talk? So I asked them to research their work, to invite, to read some of their basic writings, and then they engage in this fictional dialogue. I can tell you this is very, very interesting and always challenging because, of course, they acknowledge that they come from different contexts. But for the next 2 minutes, I want to highlight what it comes out of this exercise, and it's fascinating. They find out, that all three speakers, they declare a common thread of decency. Now, I don't know how we understand decency. If we understand decency in a very minimum way, in the way that Avishai Margalit has developed in his own works as avoidance of humiliation. But when I talk about decency, I'm saying that this decency, is linked to the concept of moderation and to the concept of humanity. But not humanity in these abstract terms that we all international lawyers want to talk about humanity, the Kantian theory of humanity. Humanity in the sense, of being humane to each other. It's a humane in the personal direction between a human to human. So with this fictional dialogue, these three different personalities from different eras, different contexts, from these fascinating cities, which is not a coincidence that I chose being around Mediterranean, they try, to instigate, to generate, an understanding, a humane understanding, for the alleviation of pain. And I call that this understanding is a vaccine against cruelty. I'm not saying that it's a vaccine, that disappears the pain and the misery and the suffering. I'm saying that this is a vaccine, that may alleviate the pain. And in that sense, this is it's a moderate response, to human suffering and to human pain. So this exercise, ends, students, have to make presentations, and then I'm asking them, what do you get out of that? And the response they get, is that they realize that individuals can make a difference. Because in the National Legal Scholarship, when we teach international law, we always talk about abstract projects, respect by states, respect by abstract entities. But here we are talking about individuals. And usually people say, yeah, you cannot save the world, if you behave that way. And students understand that they may not save the world, but those individuals, with a particular traits, with a particular ethical standing, and this combination, as I say, of empathy, humanity, phronesis, moderation, but also courage, they can save the lives of some people. And in that sense, they operate as exemplars who understand the imperfection of human nature, a human nature, which is far from perfect, which is possible for the worst, but it's possible for the best. And I'm saying, I complete this short note by saying, in that sense, these exemplars, becoming an exemplar is not it's not an easy task. It's a very difficult task, but it appears to be the most rewarding task, of individuals who manage, to stand up, to speak out, and to trigger some difference in the lives of some people. So I stop here, I don't know if that made any sense for you with all the noise from Terminal 2, but I would be very happy to discuss more about those ideas. Thank you.
Perfect. Many thanks, Maria. First of all, I think that's probably the most impressive conference intervention ever made from Terminal 2 of Heathrow Airport. I did have time to read your paper this morning, and a lot of the work that I do at the centre, we spend a lot of time with IHL capacity building, but with humanitarian actors or different civil society actors. And I think fundamentally you're onto something. I think the IHL sector generally is very small. Academically, I think it's quite small, but also when it comes to organisation specialists in IHL, we have ICRC, we have Geneva Call, and we're quite a new centre coming into this space. And I do think that we would like a bit of innovation in how we approach, and even though I think we probably come from quite different perspectives, but ultimately one of the questions that you raise, and I think it's the fundamental one, is how could we persuade the opposite parties to respect IHL and secure lives of those trapped in conditions of siege? Because ultimately this is a persuasion game. And often what I've seen is that IHL lawyers are very good at talking to other IHL lawyers, but not perhaps so good at talking to others. Even humanitarian actors that we work with, we see these big advocacy notes coming out, targeted toward the armed actor, quoting, this provision, that provision, assuming that actor finds notions of international law to be relevant, just because we find it relevant. So we've had experience working in Myanmar and a few other contexts where actually we need to think about what other interests, other normative frameworks could you invoke to, again, ultimately persuade actors to maybe reconsider their conduct and behaviour. So I have to say they're just some initial thoughts I had from reading your paper, and I very much support, I think, a need and a very interesting approach you have to your teaching of IHL. And maybe just one question: what do you think is behind? And maybe I don't want to put words in your mouth, but perhaps sometimes the reluctance of international scholars or international lawyers to alter their discourse or to bring in other concepts of emotion and ethics. What have you seen is sometimes something that stops or prevents that type of more innovative or more kind of creative thinking? Oh, Maria, I can't hear you. Maybe others can. No. Yes, I think you're back.
Yes. So thank you very much for the question and comment. And once more, I apologize for the very late submission. So what it is? Well, when we started this project on virtue ethics, imagine even in Helsinki, everybody say, "Are you crazy?" Because ethics, are considered to be an anathema. Whether you take it from the perspective of positivist lawyers, so-called mainstream, I hate this word, or you take it from the perspective of critical legal studies, ethics, it's a hegemonic project, it goes directly into the Kantian theory, the Kantian ethical theory. And then emotions for a long time from different schools of thought, they were considered to be an antithesis, an oxymoron, I mean, there is an uneasiness among lawyers, and I can tell you it's a self-challenge with me, when I teach international law. Every time, I'm critical, I'm this, I'm that. Then at the end of the day, I ask the students, what do you get, out of there? What do you get? What is the difference of international law? What is the added value? But I think, our approach of focusing on individuals, for me, makes more and more sense, because we know that individuals in different positions, whether it's a Secretary General of the UN, okay, or it's a particular director of another organization, or it's an individual in your work, with different traits, they can do a good job, they can convey better messages, they can become exemplars. And this is where we acknowledge the limits of law, the limits of, not of law, the limits of norm application. The idea, it's like what I experienced when I was at the ICC. Oh, we have the Rome Statute, we apply the Rome Statute. All of us, we know that this is not how it works. Let's start with it. Who are we kidding, So it's a matter, of moving beyond our self-righteousnness, and acknowledge that, okay, let's take law, and that comes from all schools of thought, Let's take the law, let's acknowledge that it's a social phenomenon. We all know that it's a social phenomenon. And let's see, how you can have different results, different application, different generation of respect, coming from different people. Because as you say, going to Myanmar and going to somewhere and tell people, oh, these are the Geneva Conventions, blah, 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 blah. And sorry, I don't want to be dismissive, but you understand, take that, read them, and now you have to respect. It doesn't take us far. And this is something that we really have to understand, because there is an uneasiness. It's insecurity on behalf of us, to accept the limits of law. The limits, not of law, the limits of the automatic application of norms, that there is no automatic application of norms, that you need to generate a better understanding, that you need to invest, and that particular people, and there is nothing, we should not be afraid of other disciplines, of other actors, who try to help on that. So I think, there is a massive issue of insecurity among scholars, not to lose, our myth, not to fall from our castle among legal scholars, that we have the only privilege to talk about law.
Many thanks, Maria. And I think this interdisciplinary approach, also mentioned by Joanna this morning, is really, really important. And even this week, I had a lecture with the students at the Swedish Defence College, and I always think I come in as the very positive humanitarian. They see the military perspective on IHL. I come in with this very positive approach. Although one student took me back when I opened the floor for questions, and they simply asked the question, is there anything good about IHL? And I was almost so taken aback, but it made me think, actually, I'm maybe not doing a very good job here, and maybe reinforcing some of that cynicism. I think I would like to take this moment now, with 15 minutes to go, to open the floor for questions. I see that there is already one question directed to you, Eve, from Francisco Lobo. Hopefully you can see the question. I had a problem yesterday seeing some of the questions, so hopefully you can see that. And I invite others who are interested in raising questions to our panelists to please also do so in the question and answer box. But maybe Eve, you can kick us off.
Certainly, and so I did just pop a little response to Francisco in the box, so hopefully you can see that as well. The question was around the nature of the Common Article 1 obligation, and whether I saw it as an obligation of conduct or an obligation of result. And my response is definitely that I see it as an obligation of conduct. It's my view that something was intended by the drafters. I don't think there are provisions of international law that are generally just thrown in there to not mean anything, and certainly not the first provision of such a seminal document. So I think it was intended to mean something, and if you interpret it as an obligation of result, it's very hard to practically see what that meaning is. So my view is that it is an obligation of conduct. that very much depends on the due diligence aspect. So that obligation to think about, in the circumstances and the particular thematic area of IHL and the particular actors that are involved, what might be able to be done. And, I guess that links nicely, although Maria's presentation is obviously very different. I think it was really interesting to hear, her conclusions around sort of individuals making a difference and the role that individuals can play. And I think that that's absolutely, the conclusions that I have as well from looking at the obligations of states. So there is an obligation on states, but there are all of these other actors in the community who need to play a role. And the obligation on states includes the facilitation of that role of the individual actors, including the religious actors that we're talking about today. So a little bit of a response to Maria's excellent presentation, but also to say, yes, I believe it's an obligation of conduct.
Brilliant, thank you. I see there's no currently, but please don't be shy to ask more questions. But I think we have a question from both Joanna and Ezekiel. So Joanna, maybe go first, and then I'll hand over to you, Ezekiel, for your question.
Thank you so much, Steve. Can you all hear me? I think you can hear me. Maria, 2 questions for you. The first one is, where do you think there's this reluctance in the humanitarian sector and among us international lawyers in academia? Where do you think does this come from for the engagement or the thinking of how religious actors and religion may play a role in the persuasion process? And the second question, also for you, is, did you get an applause from the audience on Terminal 2? You have to unmute yourself.
Sorry, Anna, I missed the second question, sorry.
Oh, that was the better question. I asked if you got a round of applause from Terminal 2 audience.
Well, there is a dog behind me, so.
So the attention is on the dog, yes.
Yeah.
Both Steve and I know how that feels, being dog humans. Brilliant, thank you.
Stephen, should I go now? Should I respond to that?
Yeah, please, you go ahead. I had a few thoughts as well, but please go ahead.
Ioanna, thank you very much for that. I think with religion, it's very much, that's my understanding, at least, it comes from suspicion towards natural justice, towards natural law. And all these elements, that I mentioned, the way I understand that is things, that we can talk about humanity, but humanity in a more modest way and equally moderate way. We talk about, decency. We talk about traits, that they are also to some extent linked. It's the ethics. The ethics is, as I say, I keep saying that it's an anathema when it comes to positive law. Now, I wouldn't expect that thing would be so strong in IHL. To the opposite, I expected that it would be less. It wouldn't have that strong reaction, but it has. And I can tell you, that my interest in this topic, were mostly instigated during the last summer when I saw, among international legal scholars, blog posts, yep, exactly, with fictional dialogues as well, I'm not going to name, and where, there was this idea, what's the point of international humanitarian law? What's the point of us? What are we doing? At the end of the day, we cannot convince anyone. There is this massive determinacy. We become ridiculous, that type of things, and there were other blogs saying, no, it matters. So you could always see, that this kind of self-challenge, but again, with particular school of thought. I think also it's very much goes back, whether we very dismissive, very ironic about religion, very, very hesitant about religion, whether, as I say, it was coming either from positive law or from critical legal studies. So when I was talking personally about virtue ethics, I got a kind of an ironic eye from both schools of thought. You know, what are you talking about? You know, oh, you discovered Aristotle, you discovered, you know, kind of natural justice. Are you serious? So, and something that Stephen, I think, talked about, that the last years, you know, religion has been linked, you know, to some religion, you understand, like, to some manifestations of extremism, blah, 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 blah. So there is there, you know, a negative connotation that requires, you know, both of management, better management. But I really think, you know, that it is related to ethics. We have a bad experience with ethics, with moral interventionism and stuff like that. So now, you know, to start talking about ethics, as I told you, when we started this project in Helsinki, everybody say, how did Marty allow that? Well, Marty had nothing to do with that. It was Jan Klambers who was doing this. But already the idea to work on ethics in Helsinki was considered to be, wow, you know. So thank you.
Thank you, Maria. And maybe also just quickly, and my answer is can be far less sophisticated, but I just agree. I think there has been definitely within the humanitarian development sector, again, often a bit of reluctance or nervousness to engage with religious actors. I come from we work with a development organisation, and we have some really interesting kind of reflections on the real challenge that religious actors play in particularly sexual and reproductive health development projects. Then when I actually turn to the humanitarian community, I think, if I'm a bit self-critical, that when us as IHL scholars, when we engage in training, so there may be a 1 day or a week training, whatever, we bombard them like, this is important, here's all the information, it's super complex. But for me, for humanitarians, of which IHL is for most kind of, be it program officers or delivery of programs, it'll be a factor somewhere in the whole menu. What we don't say, well, okay, here's how it can be helpful, here it can be counterproductive perhaps to your humanitarian goal. Also, here's where to put it aside. And actually, increasingly, a lot of our legal advice to humanitarian actors is actually don't refer to IHL on this. And I think it's important that we focus much more in our engagements to really think ultimately, why are we working with humanitarian actors on IHL? Because we all have an interest in trying to minimize or address the violations. And therefore, back to Maria's question in her paper is, how can we persuade actors both for preventative work, but also responding to violation? And I think that's something that we need to work collectively with a whole range of actors, religious leaders, think about different normative frameworks, and also about just basic interest mapping. I think sometimes as humanitarian actors, when I raise this question, why is an actor violating the law? I think we're a bit uncomfortable because it's almost like we're endorsing if we have, no, just try to understand, because at least if you understand the interests, we can maybe try to find, okay, what areas are there actually some common interest, even as someone violating the law. And again, you can use that to potentially push for better respect of the law. But again, I think we do need to be a little bit more innovative and lean on other frameworks, other approaches. So that's just my thoughts on that. If it's okay, I think Ezekiel had a specific question for you, Eve. So if that's okay, I'll hand the floor to Ezekiel.
Thank you, Steve. Yeah, I had a question for Eve. Actually, when I was listening to her presentation, so perhaps it's just to clarify in my mind is whether, so you're saying that states under Common Article 1, they have an obligation, for instance, if it is actually confirmed that religious leaders can influence positive compliance on parties to a conflict through Common Article 1 states and arguably non-state armed groups, but they can, or they should rely on religious leaders, right? This is. So my question is whether also they have an obligation not to put them at risk, you know. So the whole idea of do not harm, how does it apply in this context? Yeah, thank you.
Thank you for the question. I mean, perhaps just to say, I'm not sure that I would use the word an obligation, or use the phrase an obligation to rely. I think that states clearly have an obligation but states can give effect to that obligation by facilitating and encouraging other actors, including religious actors, to do certain things. So maybe it's splitting hairs a little bit, but I'm not sure about the phrasing of reliance, but certainly using private actors, including religious actors, to and facilitate your state obligations, absolutely, I think is a practical way to give effect to Common Article 1. In relation to sort of the counterpart of that, then the obligation not to put them at risk, I think there's a couple of very clear components to that. So the first one, of course, is that some of these religious actors, these serving military personnel who are serving as religious military actors, yes, there's absolutely very specific obligations on states to protect those individuals. That's just a part of the simple part of the IHL, the Common Article 1 part, the respect obligation. For those who are religious actors who are not serving members of the armed forces, they of course fall in the civilian bracket. But because they are religious actors and are also potentially operating from buildings of spiritual, cultural and historical significance, there are a couple of particular provisions of international humanitarian law that absolutely requires states to take particular measures not to put them at risk and for their protection. So the town planning, to come back to that, like the town planning concept of not putting your religious buildings next to your military facilities, for example, or not as a state misusing a religious facility for a military purpose. These are absolutely obligations not to put them at risk. So, apart from the ones that are serving in the military, they do fall within this civilian category, and so maybe the obligation isn't higher than it is in relation to you and I, but there still is absolutely an obligation of states to protect those individuals. They're not parties to the armed conflict, they're not taking a direct part in hostilities, and there are absolutely obligations that states have towards them, and ways in which states can use these private actors to help facilitate their compliance with Common Article 1 obligations and a variety of other international law obligations, because of course a lot of the things that states need to do to comply with Common Article 1 aren't just complying with Common Article 1, they're complying with a range of different obligations that states have in relation to international law more generally, as well as international humanitarian law specifically.
Many thanks, Ezekiel, for the question and Eve for your comprehensive answer. I still one last opportunity for those that I can't see to raise a question. If not, I'm quite happy to kind of unless maybe I could. We have 3 minutes. Any final remarks or thoughts from either Eve or Maria? Please go ahead. Shaking of heads.
No, can I, Eve, please,
yeah.
Eve.
Oh, I guess, my final thought was really, I guess, to reiterate that point that Maria was making towards the end of her presentation, that individuals can absolutely make a difference. And that's a really important part of the general obligation, but it does link to the legal obligation of states, and the work that I'm trying to do in raising awareness of the ensuring respect obligation is to look at ways in which states can encourage and facilitate the ability of individuals to make that difference.
And can I say on that, that note that Eve just highlighted, that actually, because usually when we present that part, about individuals, they say, oh, what is the legal normativity? That's what Eve, highlighted here. And then we go back to the work of Amalia Amaya, who speaks a lot about exemplars, you know, and how actually individuals with particular decisions, with particular action can generate legal normativity, developments of the legal front. And this is maybe not immediately, you know, but this is something that happens. So it's not something outside the law context. It's very much linked to that. And we have to realize that more and more. At the end of the day, all the big projects are projects of individuals, aren't they? The big legal projects. If we think about that, there were some people with vision behind that who pushed the agenda. So thank you.
Thank you both for those excellent last remarks. I have nothing further to add. I really like this. Individuals can save the world. I think it's a nice way to end the first session of this conference. Maybe there's those who are joining, just a reminder that the next session starts at 11:45 on religious leadership and armed conflict, and maybe some of the issues we've touched upon lightly will be further explored through specific case studies and examples. So yes, very much thanks all for your engagement and participation, and I hope you enjoy the rest of the conference. And of course, big thanks to the Generating Respect Project and the co-lead investigators, Ezekiel and Joanna. So thank you. Bye-bye.
Thank you very much. We shall see you at 11:45.